Welcome to Court Beyond, where the raw power of justice is revealed. Today, you'll witness two shocking cases of repeated defiance, probation violations, and blatant disregard for the law. First, Gabriel Smith, a woman whose criminal record spans years of theft, probation revocations, and escalating offenses. From minor shoplifting to felony thefts, her actions reached a dangerous peak when she assaulted a police officer during a theft attempt, transforming a seemingly simple crime into a life-altering assault case. Judge Raquel West scrutinizes every misstep, every violation, and delivers a stunning 8-year sentence in the Texas Department of Corrections, proving that repeated defiance and harm to law enforcement will not go unanswered. Next, the focus shifts to Isaiah Pedes, a man whose probation failures include repeated substance abuse, neglecting community service, and prior offenses involving a prohibited weapon and aggravated assault causing serious bodily injury. Despite numerous chances, he continues to defy the law, raising the stakes for himself and the community. While his final sentence awaits an updated pre-sentence report, the courtroom confrontation exposes his reckless disregard for the rules, showing just how high the consequences can climb when probation is ignored. Stay with us. The shocking courtroom revelations, intense confrontations, and Judge Raquel West's uncompromising rulings will keep you glued to the screen. Now let's dive into the first case and witness Gabriel Smith face the full consequences of her actions.
Okay, you're Gabriel Smith, and this is 25 DCCR 0979. There was originally a plea for a cap of 5 years that I rejected. There was a new plea entered of a cap of 8 years, and we reset it for sentencing just for you guys to get anything together that you needed. I did not order an updated report or anything just because she's been in custody. And so is everyone ready to go forward with sentencing? What did I say? Oh, 8-year cap. Yes, I'm sorry. And so, Mr. Kimler, you may proceed.
The court previously refused a 5-year cap, so I'd say the court's probably inclined to give her somewhere between 6 and 8 years on this. I think Ms. Smith recognizes the error of what she did. She's attempting to try to remediate that. I'm thinking, I understand she is going to have to be some time on this, but I think that she regrets what happened, and hopefully, not engage in conflict and conscious to return. It was at that case that would have died when the officers had been misfelt, but she really coached the officer and initiate some sort of contact with him. It was for her. It was an unfortunate incident where, and I'm not contesting either culpability or guilt, but where the officer reached into the vehicle with a forward injury. So, yeah, we'll see if the court repeats fine. Court's inclined because of criminal history. You have to 6 got 8 years. It's argued for 6 at the lower end. I know she has extensive criminal history. She wanted to address which one said that. So we have to say, we said, you have a lot of fun in this situation. Like, went on. Yeah, foolish. Anybody that was involved in the case of something, I don't know, but seriously. Yeah. To whatever you give this, thank you for this.
Okay, thank you. Ms. Malvino?
Judge, I think 8 is probably still too low based on the criminal history, but I would agree with Mr. Kimler that the underlying nature of the offense started out as a simple shoplifting case. It obviously went well right. She could have injured the officer even more so. That being said, in combination with her criminal history, it's not simply just a shoplifting case, and I think it's sort of the various.
So, Ms. Smith, the thing is, your theft convictions they start back in, it looks like 2007. And you've got a full page of page and a half of misdemeanor thefts on this pre-sentence report, where you were put in the parish jail. And then you proceeded to keep doing it. So they started adding up to felonies. You had probations that were revoked on 4 different theft cases that were misdemeanors that ended up as felonies that ended up with you going to prison. 5 years was, it looks like you got 5 years in 2016, 3 years in 2017, and then another year in 2018 in prison for the same thing, shoplifting. And this one, you're shoplifting and you end up climbing in your car. And I mean, just the, what went on with you and that officer is ridiculous, because you're trying to steal again. And now you end up hurting an officer in the process of them trying to stop you from stealing again. I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and in cause number 23, DCCR 1034, finds you guilty of robbery. Sentence you to a term of 8 years in the Institutional Division of the Texas Department of Corrections. You do receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am going to hand you the trial court certification that shows this was an agreement I followed, so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Be sure to read that written admonishment I provided you to see what devices qualify as a firearm. If you have questions about it or how long it lasts, you can talk with Mr. Kimler.
The wrong case number.
I did.
You went on the robbery, and that we actually entered the plea on the assault.
Sorry. 25 DCCR 0979 finds you guilty of assault. So I will withdraw the finding of guilt on robbery, find you guilty of assault on a peace officer. And all of the rest applies as far as the sentence and the cause number, again, 25 DCCR 0979, correct? Thank you.
So that she wanted to make sure it's not.
No, it's not aggravated. All right. And we have to have that discovery certification today because the case is going to get closed out.
Again, you never get.
Well, I mean, the first, when she first fled.
You didn't get it.
To give me
All the credit that you were in, any time that you were on this case and there was a hold on you or you were in our custody, you get credit. Okay?
Thank you.
Good luck to you. 8.
What we've just witnessed is the full impact of repeated defiance. Gabriel Smith's history of theft, probation violations, and assault on a police officer led to 8 years in the Texas Department of Corrections, as Judge Raquel West made clear that reckless behavior and harm to law enforcement will not be tolerated. Following this, the focus shifts to Robert Isaiah Pedes, a man facing multiple probation violations, substance abuse, and prior offenses involving a prohibited weapon and aggravated assault causing serious bodily injury. As Judge Raquel West prepares to assess his actions, the courtroom confronts the consequences of repeated negligence and defiance, proving that probation is not a free pass when serious crimes are involved.
All right, sir. Are you Robert Isaiah Pedes? And Mr. Pedes, best you can, please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. And so, Mr. Kimler, will your client waive the formal reading of the motion in each case?
You will.
Mr. Pedes, in cause number 16-24053, I have a motion to revoke your unadjudicated probation. This shows that you were placed on probation November 14th of 2016 for possession of a prohibited weapon, third-degree felony, and that was a 10-year deferred probation. Is that correct? Cause number 20-35329. I also have a motion to revoke your unadjudicated probation. This shows that you were placed on probation March 7th of 2022 for aggravated assault causing serious bodily injury, a second-degree felony, and that was also a 10-year deferred probation. Is that correct? And then finally, in cause number 20-35328, I also have a motion to revoke your unadjudicated probation. Shows you were placed on probation March 7th of 2022 for aggravated assault causing serious bodily injury, a second-degree felony. That was also a 10-year deferred probation. Is that also correct? Each of these cases allege that you violated your probation Count one in each case alleges that you failed to enter and successfully complete the JCDI program. Is that true or not true?
True.
Count two in each case alleges that you provided a urine sample June 12th, June 24th, July 10th, and July 31st that tested positive for tetrahydrocannabinol. And is that true or not true?
True.
THC or marijuana. Okay. Count three in each case alleges that you provided a urine sample July 31st of 2025 that tested positive for cocaine. And is that true or not true?
True.
Count four in each case alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true?
True.
You sure?
Well, I did one. I did two right before he passed. Like a month before I turned myself in. So
2 hours.
I did 2 days.
Two.
They said they were gonna give me about 13 hours a day.
I mean, it's probably not true. But I
I
don't
don't
know.
know. Yeah, I should have done about 25, 26 hours.
Okay. Well, do not true for that. Count five in each case alleges that you failed to submit to alcohol or drug screening as ordered June 18th, June 25th, July 2nd, July 5th, and July 21st as ordered. Is that true or not true? Okay. Count six in each case alleges that you're behind in your court assessed fees. Is that true or not true?
True.
Did you enter your pleas of true in each case to counts 1, 2, 3, and 6 freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yeah.
All right, then each of your cases, I'm going to find that you entered your pleas of true to counts 1, 2, 3, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probation. However, I'm going to reset your case so that the probation department can do an updated pre-sentence report. That'll give me more information about you, your probation, what's been going on. Also, at that hearing, if the state has any evidence with regard to those other counts, they'll be allowed to put that information on. Anything that you think is important for me to know, make sure you get that information to Mr. Kimler. He will present it to me on your behalf when we come back. These are unagreed. They're so let me make these notes and then Brittany's name. All right. So Mr. Kimler also filed a request that I set bonds in these three cases. There are currently no bonds set. Is that correct?
Yes, sir.
Mr. Kimler, you may proceed.
Your Honor, I, I appreciate the fact that these are serious cases too, and assaults and serious bodily injuries, and it's not a primitive weapon, which I believe was a short barrel firearm. I don't know whether it was a rifle or a shotgun. Which I guess at first glance would be indicative of so much potentially dangerous to the community. I can only observe that the evaluation by the state, the probation department, and I suppose the court of these cases initially was that they were more worthy of deferred adjudicated probation. Um, the finished performance on probation is has not been sufficient. He's fallen short. I would low observe that there are no allegations of a new offense, but he has been remiss in taking care of his obligations. I don't know that he appreciates really the seriousness of what he's looking at in the event of a revocation. I could say that because somebody that's facing 20 years in penitentiary on an aggravated offense that can't refrain from the use of marijuana or THC probably hasn't taken their probation seriously and doesn't fully comprehend the severity of what he's facing. I would ask the court to set bonds in these cases at an amount, hopefully, where he can meet those bonds in order to get out of jail and demonstrate to the court during the time period the court just waiting on the updated pre-sentence report that he can get back on track or get on track with his probation and hopefully perform community service through whatever evaluations that are necessary and demonstrate to the court that he can refrain from the use of illicit substances. Really, it's kind of an opportunity for Mr. Paredes either to demonstrate to the court that he has the desire and ability to complete probation or not, and he comes back to the court in 30 days and hasn't done anything on probation, then obviously the court would take that into consideration to revoke the year up to 20 years penitentiary on an aggravated offense. So it's really will be up to him, and I'd like him to have that opportunity.
Well,
To come back.
let me just stop you because Mr. Paredes has had every opportunity. Mr. Paredes was on probation for that prohibited weapon case, placed on probation in 2016. Then we have 2 new aggravated assault causing bodily injury indictments while he's on felony probation. And for whatever reason, got another opportunity on those 2 cases at a deferred probation, has been given every opportunity. There was an MTRP filed. He wasn't revoked before. He was given probation, a deferred probation, which probably I did deferred on those so that if he did continue to violate, that I would have the entire range of punishment. If I had to guess, that's probably what my thought process was. Given an opportunity at JCDI where he was unsuccessfully discharged, where they're trying to help him with all of these things. I think based on all of that, the underlying offenses, the nature of the aggravated offenses, the fact that the first one had to do with a prohibited weapon, I do not think it is in the best interest of our community while he's out using cocaine, marijuana, getting kicked out of JCDI and on probation for these serious offenses, that he be given a bond at all. And I am going to find, based on the criterion 17.15, that it is not in the best interest, that even though this is a deferred probation in each of these cases, because there's 3, because there's 2 aggravated, that it is not in the best interest of anyone that he be granted a bond in any of these cases. There will be no bond in all 3 cases.
Yes, Your Honor. I would just urge you conformity with the motion that I filed for a speedy revocation hearing since the court's denied bond we have for him. For this
We just had yeah, I mean, he just pled true, and so we'll get the updated report and get it set immediately after that.
I think in Article 42.8 embodies an idea that there'll be a dispositive hearing within 20 days if the bond is reduced. That's my rating of it. So we need to get an expedited PSI if there's denial of bond. It's in the motion, the 20-day requirement if a bond's denied.
All right, let's get it. Okay. All right, we'll get it set in 3 weeks. We'll set it for 3 weeks. Go back with the bailiff.
What we've just witnessed is a stark display of the consequences of repeated negligence and defiance. Robert Isaiah Pedes' probation violations, substance abuse, and prior offenses involving a prohibited weapon and aggravated assault brought him face-to-face with the full force of the law. Judge Raquel West made it clear that continued disregard for the rules and public safety will not be tolerated. This case serves as a powerful reminder that probation is a privilege, not a free pass, and that the courtroom enforces accountability without compromise. Here on Court Beyond, we bring you the most intense courtroom moments, exposing the truth behind criminal actions and the real consequences that follow. Stay tuned for more shocking courtroom drama. Hit like, subscribe, and comment to share your thoughts. Justice never sleeps here on Court Beyond.